Hello, my name is Joseph Greenlee, and this is the third video in a series in which I will be interviewing authors about their Second Amendment scholarship. Today, I am pleased to be joined by Jamie McWilliam. Jamie graduated from Harvard Law School. He recently completed a clerkship with Judge Lawrence Van Dyke of the Ninth Circuit Court of Appeals, and he is a very prolific young scholar in a field in which young scholars are desperately needed. Jamie has authored 9 articles, and I believe has two more in the works. And his articles have already been cited in 5 cases, including decisions by 3 federal circuit courts of appeals. Today, we will be discussing 2 of Jamie's articles, the relevance of common use after Bruin and refining the dangerousness standard in felon disarmament. These are especially important because these are 2 of the top issues that courts are wrestling with right now. And I think they are 2 of the next, maybe, if I had to guess, 2 of the next 3 issues that the Supreme Court will address in the Second Amendment field. Specifically, the common use issue is central to bans on particular arms, such as bans on so-called assault weapons, large capacity magazines, and everything, butterfly knives, switchblades, and billy clubs. And the dangerousness issue is central to bans on particular people from owning firearms. So, for example, nonviolent felons or marijuana users. So thank you, Jamie, very much for joining us to discuss these articles today.
Yeah, thanks for having me.
So let's start with your article, The Relevance of Common Use After Bruin, which was published by the Harvard Journal on Law and Public Policy. As I noted, whether arms are in common use is central to whether or not these arms can be prohibited. So let's start from the beginning. Where does the phrase common use come from?
Yeah, so the common use language comes from a 1939 Supreme Court case called United States v. Miller. That case involved a challenge to the National Firearm Act's regulation of short-barreled shotguns. Although the opinion doesn't really get into it, the background of the case is actually pretty exciting. It involves like prohibition-era gangsters, like bank robberies, things like that. And the defendants eventually get caught possessing an unregistered short-barreled shotgun. So the Supreme Court gets the case and issues an opinion that, by today's standards, is probably pretty wild. In upholding that part of the NFA, the court relied very heavily on the nature of the militia at the founding. The court first looked at who the militia was. In their words, all males physically capable of acting in concert for the common defense. The court then noted that these men were expected to appear bearing arms supplied by themselves and of the kind in common use at the time. And so that's where the common use language starts to creep in. In that case, the court reasoned that short-barreled shotguns were not in common use for the lawful purpose of serving the militia specifically. And because short-barreled shotguns were found to be not commonly used for that purpose, the court upheld that part of the NFA.
So Miller was, as you mentioned, a goofy case, perhaps a collusive case designed to undermine the Second Amendment, but
Yeah.
whatever its intent, nobody was really 100% certain what it said. Created a lot of confusion over the next 70 years. Some people thought it meant only bearing arms in the militia was protected. Other people thought bearing only militia arms were protected, but Heller clarified that neither of those are really true. How did Heller interpret Miller's common use language?
Yeah. So like you said, at the time of Heller, the big debate was, whether Miller's focus on the nature of militia and the militia service meant that the Second Amendment only protected the right to keep and bear arms in connection with militia service, or if it protected an individual right, disconnected from the militia. And Heller, as most people probably know, did acknowledge an individual right to bear arms. So Heller didn't read Miller to say that the right was limited to militia service. Instead, it viewed Miller's examination of the nature of the militia to mean more that the Second Amendment protected only certain kinds of weapons, namely those in common use at the time, because those are the kinds that the militia members were bringing for service. And specifically, the court read Miller to stand for the proposition that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes, such as short-barreled shotguns. And kind of to back that up, the court found that reading supported by this nation's historical tradition of prohibiting the carrying of, quote unquote, dangerous and unusual weapons.
After Heller comes New York State Rifle and Pistol Association versus Bruin. which I should mention was NRA's win in 2022, in which the Supreme Court held that the Second Amendment protects a right that belongs to all Americans to carry arms in public. But Bruin, almost as importantly, clarified what the appropriate test is for Second Amendment cases. Before Bruin, after Heller, before Bruin, courts were applying this two-part test that involves some interest balancing of rights and upheld. I had looked into it one time. It was like over 95% of Second Amendment challenges failed.
Yeah,
Every law was being
insane
upheld.
amount.
Yeah, speaking of Judge Van Dyke, he mentioned in a dissent that like the Ninth Circuit had upheld all 50, like 50 out of 50, 100% success rate for gun regulations. So Bruin comes in and says this test is no good, this two-part test they're using, and you have to use a test based on text and history. Specifically, you look to if the regulation burdens conduct covered by the Second Amendment's plain text, then the government must prove that its regulation is consistent with the historical justification. The historical tradition of firearm regulation. So we have this new, it's not really a new test. I think Heller established it and applied it. But anyway, it's viewed as a new test after Bruin in 2022.
Yep.
And so an important issue is where does common use fall into that? But I guess the first question that should be asked is, did Bruin mention common use at all?
So it did, but it said very little about it. So it first kind of reiterated that the common use standard was supported by this historical tradition of prohibiting the carrying of dangerous and unusual weapons. Then, as you said, it put forth this new test where you first look at, just the plain text to create this presumption of protection. And then if it is protected, then you look at the history to kind of define the bounds and find the limits of the Second Amendment's protection. But Bruin mentions common use again at the beginning of its textual examination in basically a throwaway line. It just says, nor does any party dispute that handguns are weapons in common use today for self-defense, which, to me sounds like you're basically just saying, look, this is not really an issue here. So we're just going to get that out of the way and move past it. And then the next time the phrase is used, it's in the discussion of the government's proffered historical tradition, where the court went on to dismiss the tradition of regulating dangerous and unusual weapons as relevant here because the weapons at issue in Bruin were, quote unquote, indisputably in common use for self-defense today. And that's really all the majority opinion said on the matter. So Bruin basically confirmed that the common use standard, still matters in certain situations, but it wasn't super relevant to the facts of that case. So Bruin provided very little guidance on how the common use standard fits within the, quote unquote, new framework that it put forward.
Well, let's get into whether Supreme Court precedent, what's the stronger argument, whether common use should be considered in the textual inquiry or the historical analysis. And, it's an important question. The outcome may very well depend on this issue. And some of these cases that matter most to people, specifically whether you can possess your preferred arm to defend yourself and your family. So what's the strongest evidence from the Supreme Court's cases that common use should be considered as part of this plain text inquiry?
Basically say this, is that Bruin, like I said, mentions the common use standard at the beginning of his textual analysis. And, as I said before, it's basically a throwaway line. But if you read it a certain way, it looks a lot like Justice Thomas was saying that the word arms was not at issue because whether the weapons were in common use wasn't an issue. So it kind of feels like the common use standard is folded in at this textual, what is an arms step. And there's some lines from Heller that, support this as well. If you read them in a vacuum, I'm going to paraphrase, but basically where it just says the Second Amendment, protection only extends to weapons in common use at the time, things like that. So I think that's really it. That's really what we've seen circuit courts and district courts relying on when they try to do this. I mean, I'm biased. I don't think that's persuasive, but I think that's kind of the best route for putting it in the plain text.
So what do you think is the best argument for putting it in the historical analysis?
Yeah. So I think that the historical genealogy of the test, strongly suggests that the common use standard belongs at the step 2 historical inquiry. Going all the way back to Miller, the Supreme Court, drew its common use language from an historical analysis of how the militia operated and how, states and various jurisdictions treated the militia. And then we get into Heller and Bruin, and they repeatedly remind us that this standard was supported by the historical tradition of regulating dangerous and unusual weapons. Now, historical traditions are what Bruin step 2 is all about. That's like the point of that step, right? Figuring out whether certain conduct or regulations comport with our historical tradition of regulating firearms. And if we look at it from the other direction, Bruin made clear that step 1 simply looks at the plain text of the amendment. And when we combine that with Heller, when Heller looked at just the plain text earlier in the opinion, it said that the term arms extends prima facie to all bearable weapons. I mean, after all, the amendment doesn't say common arms, it just says arms. And so Heller only raised the common use standard when it started looking at what the historical limitations on the right were, after it got past the kind of, plain text, what do the words say step. So conceptually speaking, the common use standard comes from one of our historical traditions, that of regulating the carrying of dangerous and unusual weapons. And if we incorporate the common use step or test into step 1, then we necessarily are importing considerations of our historical tradition there. And at that point, if that decides the case, step 2, where the government has the burden of establishing a historical tradition, is basically sidestepped and is functionally serving no purpose. Like if we start putting too much history into step 1, step 2 is basically superfluous.
Yeah. That's a good point. And I guess if I could add two additional thoughts, well, just elaborating on what you said. First, I don't see the Supreme Court as establishing or as allowing room for any limitations to be considered in the plain text inquiry. That's just, in my mind, that's just asked, does this regulation burden the Second Amendment and therefore require, trigger this historical analysis that applies to Second Amendment cases? I don't see any avenue the Supreme Court provides for allowing limitations to be injected into that. Just, does the Second Amendment cover this conduct? And you mentioned the court. It kind of says the common use standard is an extension to an extent of the dangerous and unusual, the historical limitation on prohibiting the carrying of dangerous or unusual, dangerous and unusual, that's an important point, firearms. And that's when it starts discussing common use. And in Heller, that's after. So the court does the plain text analysis as I see it from, I forget, like pages 576 to 600. And then it goes into this historical inquiry, and it goes through post-ratification commentary, pre-Civil War case law, post-Civil War legislation, post-Civil War commentaries. And then after it goes through all this history, it gets into this, it recognizes this tradition of prohibiting the carrying of dangerous and unusual arms, and then says, common use arms and common use are protected. So anyway, I would add that I think that supports your conclusion that the common use analysis question belongs in the historical analysis. So why does it matter? Why does it matter if it's a question the courts have to consider when they're confronted with these regulations on particular arms, like so-called assault weapons or large capacity magazines? If they have to answer it anyway, why does it matter if it comes in the textual or historical analysis?
Yeah, I mean, you might think it wouldn't make much of a difference, right? I mean, if a weapon is not in common use, then the challenge fails either at step 1 or at step 2. But it actually makes quite a big difference, particularly because it changes who bears the burden of proof. Lower courts, generally held that step 1 issues are placed on the challenger, while step 2 are on the government. So if common use is a textual issue, then the challenger would have to show that the weapon is in common use in order for the challenge to move forward. Whereas if it's an historical one, then the burden is on the government to show that it's not in common use. And also, it kind of changes how the framework operates. If common use is a textual issue and something is not in common use, then that's the end of the question, right? Challenger loses. If it is in common use, then the government can go on to come up with an historical tradition to justify its regulation. But if common use isn't this historical issue, then whether a weapon is in common use or not, if it's a weapon, it gets past step 1. And at that point, the government has to point to the tradition of regulating dangerous and unusual weapons to show that that weapon is comparably dangerous and unusual such that it can be regulated. So I think it just like the burden shifting is one big thing. And it also just conceptually changes how like the arguments would kind of like move through the Bruin framework.
Yeah, and that's a good point. It makes if you put the common use inquiry into the plain text analysis, then it really gives the government a second bite at the apple to say, okay, yeah, we failed at the common use question, but now maybe we can provide some historical analogs. Whereas if the Supreme Court has already held in Bruin, as I believe it did, that the historical inquiry is that common use, arms and common use can't be banned, and that's the end. So we saw
Mhm.
this in like several lower court opinions, but like the fourth en banc Fourth Circuit recently upheld Maryland's prohibition on so-called assault weapons, and they considered they went into common use in the plain text analysis. It's they did a good job of evading it, but I think it's indisputable that the most common rifle in American history is common. Um,
Yep.
and so, but they jumped around that in the plain text analysis and then said, we'll look at history anyway. And then they start looking at, historical regulations, prohibiting the concealed carry of Bowie knives or, billy clubs and whatnot. And then they're like, oh,
Hmm.
it's justified by history too. So it gives them another chance to uphold laws. Whereas if it's undisputably in common use, then that would be the end of it.
Yep, exactly.
So how have lower courts how have they been treating the common use inquiry so far? Have they been putting it in the plain text or historical analysis?
So it's been kind of a mixed bag. A lot of courts have been putting it in the plain text step, like a lot of them. Um, I think a lot of judges might be inclined to do so because of how we have like historically understood originalism. So originalism, right, has been typically been framed as using history to understand the original public meaning of the text. So when originalists see something about an old constitutional text, like here, in step one, it's the plain text, they immediately want to start diving into the history. Like it's just, like an instinct. But that's not really what the court did in Bruin. I mean, the test as a whole uses history to understand the limits of the Second Amendment right. But in step one, it just looked at the text itself. And you have a smattering of courts doing that. One Ninth Circuit panel put common use at the historical step, though that case is now being reconsidered en banc, and we'll see what the en banc court does. And you have a number of like dissenting judges that are getting it right. Judge Richardson on the Fourth Circuit, in the case you just mentioned, recently had an excellent dissent that really nailed why common use belongs in the second step. So, all in all, courts don't agree. Like this is something that's going to have to get ironed out at the Supreme Court eventually.
And I'm hopeful that'll happen in that case. That was the Fourth Circuit case we both mentioned. It was Bianchi versus Brown. Now it's Snope versus Brown, and I think we'll find out in January whether the court will hear that case, and I'm hopeful that they will.
Yeah.
Uh, so when the Supreme Court does address this issue, how do you think they will decide it? Do you think they'll put it in the consider common use in the plain text analysis or historical inquiry?
Honestly, I'm not sure how opinions will line up on the court. I think it's likely that there'll be disagreement, like even among, you know, the two kind of sides of the court. Um, I do think it's possible to get a majority for putting common use at the historical step. I think it's apparent from Bruin that a lot of the justices have an excellent grasp of conceptually what was happening in Heller and Miller. So if they follow the logic that they have been, I think we would get common use as a step two inquiry. But you know how they actually how that breaks down among the justices, I'm not sure, um, and how that would play out for specific issues like the assault weapons bans or large capacity magazines. It seems like either way, those are very widely used, so it'd be a very hard argument to soundly show that those are not in common use today.
Yeah, I agree. I think and if there's any hope of upholding those laws, you have to put it in the plain text, the common use inquiry into the plain text analysis, because they number the so-called assault weapons in tens of millions, and the magazines that are typically banned hundreds of millions, over half a
Yeah.
billion. So it's hard to say those aren't common. Uh, so yeah, thank you, and hopefully the court considers when it does hear the case, considers your article on it. So let's shift gears here and discuss dangerousness. So this issue, as I mentioned in the beginning, is central to prohibitions on particular persons, such as felons or drug users, marijuana users, and several others, to provide just a very brief history of this issue. So up until about 2019, the prevailing argument in courts that courts were adopting was that the government could disarm anyone who lacked virtue. The argument was that, and there were pro-gun scholars viewed as being kind of more pro-Second Amendment, and scholars viewed as being more anti-Second Amendment, who kind of all agreed on this. That and originally in the founding era, if you were considered unvirtuous, you could be disarmed. And this was really sweeping through the courts, and then subsequent research revealed, and then Judge Barrett's dissent in Cantor versus Barr kind of simultaneously revealed that this was just nonsense. It was just made up. There was no historical law disarming anyone for lacking virtue or any kind of historical principle allowing it. So the research shows that really only dangerous people could be disarmed historically. And but so your article comes in and says, well, that seems right, but what does dangerousness mean? So I guess the first question is what types of people are currently prohibited under the law from possessing firearms?
Yeah, so the rules under 18 USC section 922 G specifically disarm a variety of people. I mean, like you kind of mentioned earlier, felons, drug abusers, mentally ill, illegal aliens, others, basically groups of people thought by some to pose an increased risk of danger to others beyond like your average people.
And many of the laws do effectively cover dangerous people, but many of them are broad and sweep
Mhm.
in, sweep much more widely than that. So, for example, you discussed in your article the Range case, Range versus Garland. Can you describe that one?
Yeah, so in many ways, range is kind of a poster case for how over-inclusive Section 922G can be. Um, Before I get into the details of the case, I want to note that G1, the felon disarmament rule, actually disarms anyone who has been convicted of a crime, punishable by over a year in prison. You don't actually have to be sentenced to over a year; it just has to be like a possibility. So in range, the challenger had committed welfare fraud like a long time ago in order to feed his family during like a particularly rough time in their lives. Pennsylvania, where the crime occurred, did not consider the crime to be a felony, but it was punishable by over a year in prison. Though Range himself, I think, got like 3 years probation and some fines or something like that. But since Range's misdemeanor crime was punishable by over a year in prison, Section 922G1 forever barred him from owning a firearm. The case eventually went up to the en banc panel of the Third Circuit. There, the government presented a history of disarming like loyalists and Catholics, similar groups throughout the colonial founding eras. Um, the en banc court rejected those analogs because they were not analogous enough to Range's like specific individual circumstances. He's just a guy trying to feed his family, right? Um, and Range is incredibly important because, and you can probably correct me if I'm wrong here, but I believe it was the first post-Bruin circuit case to hold that 922G1 could be unconstitutional as applied to certain defendants. And that was, a game changer as far as like the last, 20 years have gone on analyzing this issue.
Yeah, and just to add even more details of Range's case, as I recall, he was uh, mowing lawns around town, around his neighborhood to earn supplemental income, and left that income off of a food stamps application in 1995. And
Yeah.
30 years later, he still can't possess a firearm. So it's a good case to get up there to show how extreme these laws can apply, and they cover a lot of people like in similar situations, people who wrote a
Yeah.
bad check at a grocery store knowingly, decades ago. It's another one, Vincent versus Garland in the 10th Circuit. So how have other challenges to 922G1 fared since Bruin, other than Range?
Not as well. I think the like seventh, eighth, 10th, and 11th circuits have rejected challenges to 922G1. Some of them did so on the basis of actually doing an historical analysis like Bruin told them to, while others basically just said Bruin didn't abrogate the prior precedent and just, mindlessly followed that precedent. The Ninth Circuit recently briefly went the same way as Range, but then that case was taken en banc, as of course always happens when a Second Amendment challenge succeeds in that circuit. So a lot to say, circuits are split. Seems like most of them are leaning towards upholding G1 pretty broadly. The Third Circuit, maybe the Ninth Circuit might go the other way. Definitely something that is going to have to be figured out by the Supreme Court.
I should have mentioned that range. Now that I think of it, it was GVR'd after Rahimi. The Supreme Court decided U.S. versus Rahimi in June of this year, and so the court kicked it back. Supreme Court kicked range back to the en banc Third Circuit. Arguments were heard. I think that was just last. No, that must have been 2 weeks ago. I expect that they'll come down this. I don't think anything about Rahimi changes the ruling in range, so I think that'll stay good law in the Third Circuit. Hopefully, reach the Supreme Court, and the Sixth Circuit left open the door recently for it was a case involving a dangerous person. But as they went through the history, they said, non-dangerous people, they certainly might have an as applied challenge here. So we'll see. And yeah, discouraging that the Ninth Circuit, as mentioned, Judge Van Dyke in a dissent right before Bruin said, this court has upheld every single law, over 50 laws that have come before them and Second Amendment challenges, and whenever there's a win in the Ninth Circuit before the three-judge panel, they'll inevitably take it en banc and reverse
Yep.
it. So hopefully that trend comes to an end, but we'll see. So for the courts that look to the historical tradition, as you mentioned, some of them follow pre-Bruin case law, just upholding felon bans. And without getting too into the details, there's a line in Heller that says, nothing in this opinion shall cast doubt on longstanding prohibitions on felons and the mentally ill, and a number of other laws. And some courts have said, and then in a footnote, Heller says, these laws are presumptively lawful. Some courts have read that as saying these laws are conclusively lawful. So any challenge to any ban that applies to felons is constitutional, even if Pennsylvania makes jaywalking a felony, then that's a constitutional ban on possessing arms. But for the courts that look to the historical tradition and go through the steps that Bruin requires, looking at the plain text inquiry, then the historical analysis, what type of people were historically disarmed, and what was the justification for disarming them?
Yeah, so regarding categorical disarmament, there were a number of groups that were historically disarmed. An early one was Catholics. As I understand it, this was a vestige of Catholic Protestant hostilities in England that was carried over into the colonies and then exacerbated by things like the French and Indian War, where some people feared that Catholics would side with the French. Basically, Protestants at the time thought that Catholics would take any chance they could to turn on their countrymen, and they wanted to disarm them before violence could break out. Slaves and free blacks were other groups commonly disarmed. A lot of ruling elites seemed to think that slaves might have a bone to pick with them. Couldn't possibly think why. Ultimately, they feared violence of a slave rebellion, and so disarmed them before that could happen. During the Revolutionary War, loyalists were also a big one. The Revolutionary War effort was very aware of the ways that loyalists were undermining them by taking up arms against them or simply giving aid to the British Army. So kind of similar to treatment of the Catholics during the French Indian War. This could be seen as more of a wartime measure meant to save colonial lives. Another group, Native Americans, were sometimes disarmed, but though early laws seemed to focus more on preventing the trade of arms with them rather than taking the arms they already had. Again, Native American tribes in the colonies were continually engaging in conflict, so this was a measure meant to prevent arming those who might attack colonial communities. After Rahimi, another set of laws that will likely play a bigger role in how we view traditional disarmament would be affray and surety laws. These are a little different. As Rahimi characterized them, these are more aimed at specific individuals who have actively or would likely misuse weapons. But the common thread through all of these is that we have historically disarmed groups that were thought to be dangerous. In other words, those that we feared would take up arms to cause violence against their neighbors and their community. But how we figure out, what counts for that kind of danger is kind of murky. After all, nowadays, if we were to disarm people based solely off of, race or religion, that would obviously not be permissible. So, a big question kind of hanging over us is, there is this history of disarming certain groups. That history does not look good. What do we do with that history?
So, and the dangerousness standard is certainly alone is, I think, clearly a helpful standard for people like range, going back to range, who are clearly
Yep.
nonviolent offenders. But as you note in the article, it can be an unclear standard in others. So, for example, a drunk driver is dangerous, but in a very different way than a murderer is dangerous. So,
Yep.
what do you believe is the best way of reading and applying the history of this dangerousness standard?
Yep. So this might be a long answer, but I think the best way to resolve the issues with history and pull out a coherent dangerousness standard is to kind of step back and examine the principles that underlie not only the specific tradition of disarmament, but also the Second Amendment itself. The Second Amendment kind of comes at the end of this, long line, this like really rich philosophical tradition that values life, community, and protecting the lives of ourselves and others. And you have, thinkers going all the way back to like Thomas Aquinas through John Locke, all these people that influenced the founders, who took the idea of self-defense as a natural right very seriously, not just in the sense of personal defense against, say a mugger or a rapist or a would-be murderer, but also in a collective sense that values defending the community against foreign invasion or even domestic tyranny. And this is how we get to, one, the militia system in the colonies in early America, where every man of a certain age is expected to possess arms and wield those arms in protection of his community. But also, two, the Revolutionary War itself. It's apparent from the Declaration of Independence, let alone the founders' personal writings, that the founders viewed the Revolutionary War as one necessary to secure the safety and flourishing of their community against a government that was actively harming it. And during that effort, locally sourced and owned arms were key to the success of the colonists' defense against the British. And so, like to groups like the Anti-Federalists, at least, they recognize the need to acknowledge this natural right to keep and bear arms. For without it, self-defense was basically an empty right, whether at the personal or community level. So, kind of against that backdrop, at the root of the Second Amendment is this idea of defense, and that I think is what explains how we can synthesize a strong right to keep and bear arms with our historical disarmament of certain individuals or groups, and how we can determine when someone is eligible for disarmament. And obviously, carrying arms is one way to defend ourselves and our community. If someone attacks me and I have a gun, I can use it to repel my attacker. But another way to defend myself would be if I had a way of removing the attacker's means of attack, his weapons. Um, Clearly it's not possible to predict with any certainty who specifically is going to attack someone in the future and disarm them beforehand. We don't live in the Minority Report world. But if the Second Amendment is aimed at defending us, then perhaps anyone who has created a situation in which self-defense would be justified, then that would be kind of the core category of people who could logically be disarmed. This would let nonviolent people protect themselves with arms while allowing for the disarmament of proven aggressors, creating this kind of twofold defense. We can defend ourselves, and the attackers would lose their means of attacking, essentially. And I think this is broadly consistent with the history of disarmament we have discussed previously. To be clear, I don't think that most of those laws would be constitutional today, but the general principle behind those laws of disarming those that take up arms against others in the community, I think that's fulfilled by my proposition that disarmament is constitutional only if one has been adjudicated to have created a situation in which self-defense would have been justifiable.
But you wrote this article before the Supreme Court decided Rahimi. As a reminder, Rahimi was decided this summer. It found that surety and going arm laws from the founding era justify 18 USC 922 G8, which is a modern law that provides for the temporary disarmament of people who are subject to domestic violence protective orders. I did notice, by the way, that the court in Rahimi use language similar to that in your article, where you assert that modern day disarmament laws should be consistent with the principles underlying the Second Amendment. Similar language there, but in any event, do you believe that Rahimi is consistent or inconsistent with your article? And do you think it changes anything?
I think it's very consistent. Like you said, the way that Rahimi kind of framed the Bruin test was that we need to look at the principles underlying our historical tradition. That we shouldn't, expect to find exact reproductions of historical laws today. Like we shouldn't be trying to exactly reproduce historical laws today. Instead, that they should be consistent with the general principles behind them. And that's, exactly, like I said, exactly what I'm arguing for here. And with these laws specifically, I think you basically have to, like, because otherwise you have to, condone disarming blacks, disarming Catholics, disarming whoever. And I don't think anyone's going to do that today. But the historical laws still have to, stand for something. And so I think that their approach taken in Rahimi is the right one, particularly in this sort of context. And I think it supports, my argument here. And I think if they basically copied and pasted the general framework reasoning from Rahimi into a new case, maybe into, a future range or some similar case of the Supreme Court, I think it would, come out pretty similar for what I would have argued for here. And obviously, I think that's what they should do.
Yeah, yes. Um, so finally, if someone wants to keep up with your constant production of Second Amendment scholarship, where can they find it at?
Yeah. So my work, I mean, it's published in various law review articles, law reviews. They're consolidated on my like SSRN page and also Google Scholar. So if people want to find my stuff, they can just search my name, Jamie McWilliam, and SSRN or Google Scholar. Find my page. They're all listed there. They can download them. They can read like 70 pages of, you know, philosophy and legal history and
Yeah, you
possibly
you
enjoy that if they're a masochist.
you have a lot of good philosophy, which I avoided a little bit in this interview, but we'll discuss it another time because very very interesting, and you touch on things that I think are unique in this area that not many people get into. And by the way,
Mhm.
we'll put a link to Jamie's SSRN page in the description of this video, so you guys can access it easily. And thank you very much, Jamie. We really appreciate you coming on today.
Yep. Thank you so much.